if somebody holds somebody at gunpoint and they want to steal their vehicle, they would say, oh my gosh, shucks, I didn't know there was a child in this car. Let me pause. But they gave nobody pause. Everybody just still continued with what they were going to do.
An 18-year-old faces prison after a robbery because her car trapped a mother and her 4-year-old. The defense says she's changed. Straight A's, college acceptance, 5 months already served. But the judge has the PSI, the stipulations, and one question. Did anyone pause when they heard, "My son is in the car"?
The court is calling 2023 CR 3848, State of Texas versus Michaela Elise Johnson. Can I have parties announced for the record for the state? Defense?
Patrick Hancock for the defendant.
All right. And are you Ms. Johnson?
Yes, ma'am.
All right. We're here for sentencing. You entered a plea of no contest to robbery on December 4th. According to the plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. The state is opposing your application for community supervision or deferred adjudication. They're taking certain items into consideration. All right. Did you all have a chance to review the PSI report, state?
Yes, Judge.
Defense?
I did, Your Honor.
Any objections to the PSI report, state?
No,
Defense?
no, ma'am.
All right. State, any witnesses?
No, Your Honor.
Defense, any witnesses?
Yes, Your Honor, I do. I have Miss Alicia Franklin, Michaela's mom.
All right, Ms. Franklin. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, that nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Make sure you keep your voice up so the court reporter can hear. If you can
Okay.
state your name for the record.
Alicia Franklin.
All right, defense.
Miss Franklin, good morning.
Good morning.
You and I have spent a lot of time together regarding Michaela, is that correct?
Correct.
And you are aware that Michaela has accepted responsibility for a robbery here in Brick County.
Correct.
And today is the day that the judge can either send her to prison or entertain her application for probation or deferred adjudication.
Correct.
Ms. Franklin, let me just ask you, how old is Michaela?
As of now, she is 18. When the case started, she was 17.
And when did she turn 18?
November 3rd.
And where is she a student at?
At Roosevelt High School.
What grade is she in?
She's a senior.
And being in Roosevelt High School, has she made future plans, applied to any universities, or done anything at this point in her senior year?
Yes, she was accepted to UTSA, and we're pending.
Excuse me, please whisper.
Say it again, ma'am.
She was accepted to UTSA, and we're pending the application for Clark Atlanta University.
Very good. And how is she doing in school?
She's doing good. She's on my honor roll. Right now she has all A's and perfect attendance since she's been out.
And did Michaela request a letter from one of her school counselors to offer to the court today?
She did.
John, I tendered this to the state for their review. At some point, you'd like me to look at that, Judge.
All right, any objections to the court reviewing this? All right, you may continue.
Ms. Franklin, with regard to that letter, is it a positive review of how Michaela's doing at Roosevelt High School right now?
It is. Michaela's right now, since her release, she's at the best she's ever been. She's focused, she's serious about furthering her future for college, and she's on the right path.
I'd like to take you back to, I guess, the time around this offense. And before I do that, I want to ask you, are you a single mom?
I am.
Does Michaela have a father in her life who's active or?
He's not active, not consistently.
And does she have any siblings?
She does. She has a brother and a sister from her father.
But living in your household is just
No
you?
one, just me and Michaela.
I want to take you back to around the time of the offense. Do you remember getting a call that Michaela had been locked up for some very serious offenses?
Yes, I do.
And can you tell the court what your response was?
That she needed to sit there. I left her in there. She needed to understand what she had done and take responsibility. I left her in there for 5 months before I bonded her out, so she could understand that she didn't do anything, you know, it wasn't something small. She needed to understand exactly what she did and what she could look forward to. She needed to know what prison or their county was, what jail was.
And do you think those 5 months had a significant impact in her life?
Most definitely. I know for a fact she doesn't want to go back. She definitely has a true meaning of what jail is.
And was that your goal at that time?
That's definitely was my goal, because I could have bonded her out the same day or the next day. I mean, I could have got the financial means to get her out. So it was definitely my goal for her to learn her lesson, and hopefully we don't ever have to revisit this again, which I don't think we will. I honestly think that she didn't learn her lesson.
Miss Franklin, let me ask you, at the time when she was arrested, were there some behavioral problems that you picked up on?
Yeah, there was, but I thought she was just being a rebellious teenager. I didn't realize she was like depressed and had low self-esteem until she had suicidal thoughts. I took her to Little Ridge, but you know, they let her out and she did a little counseling here and there. So I thought she was just being more rebellious to herself. I honestly didn't know it was mental health issues there. But once I did know, I've gotten her help.
What mental health issues have you discovered regarding your case?
Definitely depression, low self-esteem. We've been going through exercises with the counseling sessions. And me, myself, just trying to boost her up and get her on the right path to feel good about herself.
And do you think you're on a positive path right now?
Most definitely we are.
She's back living at home.
She lives at home. Our relationship is really good. She's more open. We actually have conversations about how she's feeling, and I think we're on a really good path.
And that's different than what it was before the.
Most definitely. She would stay to herself more, so lock herself up in her room. You know, just for me, what I thought was normal teenage stuff, but evidently it was a little deeper than that.
Ms. Franklin, you own a business. Would you tell the judge what you do for a living?
I do. I'm Sugar Glamour Salon. A hair salon in San Antonio.
And have you and Michaela talked about her interest in working in the salon?
Yes, but actually before this she did. She was my assistant. And to be honest, I need her back as an assistant, but she wants to be a barber and to get her through college. It'll be something for her to fall back on. And I can, I'm also an instructor, so she can get some of her hours through me.
You mentioned that she's been accepted to UTSA.
Yes, she's been accepted to UTSA, but she's also, we're pending the application for Clark Atlanta, which she preferably would want to go.
And what would be her interest in studying in college?
Business marketing.
So you left her in jail for 5 months and now she's been on pre-trial release as a condition of her bond.
Correct.
I know we had one GPS circumstance that we had to take up with the court, but
Yes.
other than that issue that was straightened out here in the courtroom, do you think she's been compliant with all the rules?
Yes, she's been compliant, and I also make sure she's compliant. I mean, we get home on time, way before time. We don't take no shortcuts. So yeah, she's definitely compliant.
I know that today we had the opportunity, the three of us, you, me, and Michaela, to go through the pre-sentence report. You can see there are some pretty raw feelings on the part of the listed complainant.
Yes.
Can you tell me if you think, even before today, do you think Michaela recognizes just how serious this offense was and the fear that people were placed in and the after effects of that fear?
Yes, she definitely recognizes that. She's definitely voiced how remorseful she is for this. I know for Christmas we did, she wasn't able to actually go to the battered women's shelter, but she did produce a toy drive. So where she marketed it and we received a lot of toys, I think over 500 and took it back to the battered women's shelter. She definitely is remorseful, and she definitely understands that she put these people in fear, and it's not to be taken lightly.
Very good. Could you address very quickly whether you think your daughter would be a good candidate for probation or deferred adjudication in this court?
I think she would be a great candidate. I think, matter of fact, I know she has a bright future. This was something that she got herself into that I know she regrets. And I don't think that she should be sent to jail. She's done 5 months, and I understand that it's not the same as 10 years, but she definitely recognizes and has had a taste of what jail is, to not do this again and not be in any more trouble, and to succeed and hopefully help other juveniles and help other people who are going in that direction.
Ma'am, that's all the questions I have. The state has an opportunity to ask any questions they want.
Yes.
Any questions?
Were you aware that this offense occurred on February 8th of 2023?
Once I got a call from the Michaela when she was already in custody.
So you knew the date.
Yes,
And what day was that of the week? Do you remember?
I do not.
Would it surprise you that it was Wednesday?
I mean, I don't know.
It was a Wednesday.
Yeah.
Would it surprise you that this offense occurred shortly before 1 p.m.?
The whole thing surprised me.
But I'm asking specifically about the time at which the offense occurred. Would that surprise you? Did you know that it happened?
I did know. I mean, I've known since by reading the papers, and
Where should Michaela have been?
she should have been at school.
So do you know, or did Michaela ever talk to you about what happened during this offense?
Yes,
So you were aware that the victims in this case was a mother and her young 4-year-old son.
yes, sir.
And you had a chance to read the victim impact statement.
Yes, sir.
And did it shock you that this had a drastic effect on that family?
No, sir. I definitely understand the turpitude of the case.
So you understand what the victim's feeling when she's saying that prison would be appropriate here.
I don't think it would be appropriate for Michaela
And ma'am,
for the simple fact.
I'm gonna ask if you could answer my question. Would it surprise you or does it shock you that the victim in this case is asking for prison?
No, sir.
Is it understandable?
It definitely is understandable.
And were you aware that the other 2 people that participated in this act, that they were both younger than you?
Yeah,
So she was the oldest one out of the group, right?
okay, yes.
So she should have been able to make better decisions than the other 2, correct?
I don't agree with that. The other 2 had been in trouble, I understand, and she also was the only girl. So,
And specifically her role in this act, were you aware that she was the person that drove the car that boxed in the victim and her son?
I understand that she was the driver, yes, sir.
Specifically that boxed in the victim and
I
her son?
understand.
Nothing else to say.
All right, any other questions?
Ms. Franklin, I think I tendered it to the judge as a part of the other letter, but we did take Michaela to be evaluated by Mark Harris.
I did,
He's a licensed therapist, is that correct?
yes.
Judge, if I didn't give you that.
Yes, you did. And I reviewed it.
Okay.
It's
very good.
attached to that.
Thank you, Judge. And you had the opportunity to look at his assessment, and that's helped you on a path of understanding her now, is that correct?
Yes, it did.
All right. Thank you.
Yeah.
Thank you for coming in. All right, defense, call your next witness.
Judge, that's it.
All right, did your client wish to say anything?
Judge, I think I'm going to speak for her.
All right, so I want to let the parties know that part of my question, or maybe you can address this, counsel,
Yes, ma'am.
because it says that she is minimizing her role. And it says regarding the instant offense, the defendant stated, I have no comment at this, which I understand.
Sure. That was
But
good.
then she comes back and she does make a comment. And it says the defendant later stated, I feel it needs to be looked into more rather than what they are saying.
And I think we addressed that actually this morning, Judge. I think her point on that is she was charged with aggravated robbery. She did not possess, hold, or yield a gun. And so it's been kind of a process of explaining that to her. So I think that she's not minimizing her role as far as doing things with those young men. However, I think she's made a distinction that, contrary to what the state wants to put forward, is that she was not the leader of this. She was a follower in this, and she did not possess or hold a gun on anyone. So I think as to Ms. Ballard's point in the PSI, maybe she could have gotten out of the car and said, hey, don't do that. She didn't do it. But the point of the matter is that she was in the car and not actively terrorizing these people. I make that distinction, but I also understand that if she's there, that she's a part of it.
All right, because I'm reading the PSI. I'm sorry, reading the stipulations. And the stipulations, it says that she was the one who boxed the driver in.
Well, Judge, we're here taking responsibility for the facts. So I don't think she has said that she's not guilty of this offense. I just think she has a different interpretation of her role versus those young men.
All right. All right. Anything else from the state?
I was informed by our victim advocates that the witness on Zoom was dressed. It was a brown sweater. That's what she's saying that she was wearing.
No, the person who was on Samsung, that wasn't a brown sweater. Unless I'm colorblind or something's going on, they had on no top.
Well, all right, Judge, I just wanted to make sure.
All right. Thank you. All right.
I don't want to overstep, but I do want to make a brief argument next time.
Yes, you may proceed.
So, Judge, when I first started representing this young lady, she was in jail. And as her mother said, usually I have to field those questions, how quickly can we get her out of jail? I think Ms. Franklin took a very brave approach for a single mom, and that is that I want her to sit with it. These are serious charges. I want her to get a taste of incarceration. I want her to understand that you have to be penalized or punished for the things that you do. So 5 months passed by. And so I think that the value in that here in the courtroom today is that she has a taste of incarceration. And I think she's come out of jail, Judge, and the letter from the Roosevelt High School from Ms. Howard says she's really doing well in school. It's hard for me to believe she's 17 years old when I met her and charged with such a serious crime, and she's turned 18 and she's only 3 months into her 18th year. So, Judge, it's one of those things. She's got a bright future. She's got hopefully acceptance into a school in Atlanta. She's been accepted to UTSA. Those letters, in my opinion, Judge, from Roosevelt High School, those are hard letters to get for the defense. And that's a really fine letter that supports Michaela in her application for probation. I don't want the court to think that she's minimizing this, because we've spent hours talking about the what ifs and how you can't find yourself in that situation. Her mom was bright enough through some talking that we had to get her sessions with Mark Harris. And Mr. Harris is very good through the juvenile probation and through private practice of bringing these young people in. Young people, he specializes in young offenders and working with them with this cognitive behavioral. You can't find yourself in the situation. You can't find yourself around the situation. If you do, then you need to leave. You don't need to be boxing anybody in cars. So I think this has been put square upon Michaela. I think she's done a great job out on bond. I think she's doing a great job in school right now. I can tell you that her relationship with her mother has never been better. I just really beg this court to give this young woman a chance. A conviction and being sent to prison is going to irreparably change her life. Now, I know that there's victims out there who have had their life irreparably changed too. There's nothing we can do about that, but this is a young lady who's clearly on a positive path, and we'd like for her to stay there with the court's permission.
State.
Judge, the situation here is that they specifically targeted a mother and a young child. That child's been damaged for the rest of his life. He's gone through immense trauma. And the role that Ms. Johnson played here was an important one. She boxed them in. She's the reason why they could not get away. I understand that she's made a lot of progress after the fact, but in that moment, she could have made different choices. Choices is what she's gonna have to make going forward. It's something that the state feels that prison would be appropriate here. The victims feel that prison would be appropriate here. That's what we're asking for.
Judge, I just want to, you see more of these PSIs than I do, but it looks like the juvenile offenders who I think want a more serious role in this. I can't read this correctly, but it looks like one of them had his cases dismissed, maybe placed on probation, and then one was sent to some kind of TYC placement. So I guess if I look at that, Judge, I just argue that there will be some kind of equitable position here by the court to figure out what to do with Michaela. Again, Judge, deferred adjudication on second-degree felony is quite a good thing. I mean, we all know what deferred adjudication is, but sometimes it doesn't mean a do diddly damn in court. Here, it makes a big difference because it gives her a chance to prove herself, and it gives the court a long leash to make sure that she's doing well. I don't know what else we could bring the court to show that she's remorseful, doing well at home, doing well on her conditions of bond. So again, we would ask that the court wisely place her on deferred adjudication. Understand that she's done 5 hard months in the Bexar County Jail. I think she spoke about her fear of the jail with Mark Harris in that letter. I think her mom made a good decision, and we're hoping that will sway the court and giving her a chance at a future without being another young Black female with a conviction on her.
Sometimes the purpose of sentence is for rehabilitation. Sometimes it's just punishment. Sometimes it's protecting the community. There are a whole host of reasons. But your problem is sometimes when you've done something that is considered so horrendous, right? No matter the changes you've made, sometimes it's just a prison offense. There are a lot of people who do things that I'm sure if they could go back in time, they would have changed it. They would have said, I wouldn't have done it. But the boxing of someone in with your vehicle, and I read the PSI report and I read the stipulations. In the stipulations, the driver of the vehicle said, hey, my son is in the car. And that didn't give anybody pause. I would think that there are certain things that should give people pause. For example, if somebody holds somebody at gunpoint and they want to steal their vehicle, they would say, oh my gosh, shucks, I didn't know there was a child in this car. Let me pause. But they gave nobody pause. Everybody just still continued with what they were going to do. That's a problem for the court. So this is what the court...
Isn't the problem that she was, no matter what her role was, it was still going to be something that was horrendous because it's a robbery.
Yeah.
So and I'm not trying to argue with the court, but under that circumstance, then no one should be eligible for deferred adjudication.
Well, counsel, as you're aware, there are different types of robbery. And there are some robberies that don't involve a child. State?
Your Honor, so right here, one thing I did notice in the letter for the psychiatrist, something that is Father Andrew, I've seen it somewhere in here, is that Ms. Johnson, she said she gave them a ride but did not know their intentions, but she played a role in boxing them in. She says that she had never had or handled a gun that night. When the police lit up her car, the boys threatened her if she didn't keep going. One of the boys threatened to shoot her if she stopped. Nowhere is that brought up in the report that she had mentioned that she had said that they had threatened her. So that's just something that is.
Well, I don't think it's her feeling, so it's not going to be in a police report.
Right,
But I can tell you that was her feeling on this. She did feel threatened by these two young juvenile offenders. But we're here today to take responsibility and not make excuses. So that's our answer to that, Judge.
All right. Is there anything else before the court makes its ruling?
No, Your Honor.
No, you're not.
All right, this is what the court is going to do. Court is going to find you guilty, taking consideration 2023 CR 3850, 2023 CR 3849, grand jury number 806632. There's to be restitution of $110 to John Bright in grand jury number 806632. Give you credit for any time served. I'm going to retain jurisdiction. Your attorney will tell you what that means, and I'm going to sentence you to 6 years in the prison. Did you review what it's entitled trial court certification with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. And Mr. Hancock, you can explain to her what that means.
I will, Judge.
All right. Court is calling 2024 CR 4236, State of Texas versus Paul Anthony Luna. Can I have parties announced for the record for the state? Defense,
Michael DeLeon for Mr. Luna.
are you Mr. Luna?
Yes, ma'am.
Counsel, have you received all the discovery?
I have, Your Honor.
Did you review it with your client?
I have.
Are there any applications?
No applications, Your Honor.
Mr. Luna, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, well, we're waiving one of the enhancement paragraphs and proceeding on a repeater, aggravated robbery.
All right, is there a specific enhancement paragraph you're waiving?
Yeah, we're waiving the last one.
All right, so the state is proceeding on a repeater count with paragraph 1.
That's correct. We have no objection.
Okay. All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of aggravated robbery? Normally, that's a first-degree felony. If the state proves up the repeater paragraph allegation, then your range of punishment will be anywhere from 15 to 99 years or life in prison. Did you understand?
Yes, ma'am.
And that is for count 1 and count 2. Did you understand?
Yes, ma'am.
Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for
Yes.
any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do believe he's competent.
And was sane at the time of the offense?
Yes.
Mr. Luna, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 1 and 2. You're to agree that you've been previously convicted for enhancement purposes. Punishment is to be assessed at 20 years in the prison. There's an affirmative finding of deadly weapon. There are no applications. The state is taking in consideration 2024 CR 4237. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
That's correct, Your Honor.
State is at the plea.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No motions, Your Honor.
Outside the agreement, the state is requesting that you have no contact with Xavier Valero, Sergio Martinez, and Margarita Segovia. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to count one in an indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And count two, how do you plead? Guilty, not guilty, or no contest?
Guilty.
To the repeater paragraph, how do you plead? True or not true?
True.
State any evidence.
Yes, Your Honor.
We've reviewed that, Your Honor. We have no objection.
Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it at all the appropriate places?
Yes, ma'am.
Again, did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting witnesses in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty of count 1 and count 2. The court will find you guilty of count 1 and count 2. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
We are, Your Honor. I think Mr. Luna wanted to say a few words to the court.
All right, you want to raise your right hand?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Paul Luna,
All right, what would you like to say, sir?
is it okay if I read this to the court?
Have,
Haven't seen it, Judge.
I mean, it's not, it's just, it's not asking for no time off, not for my freedom,
Sure.
nothing like that.
Objection. No objection.
Your Honor, my name is Paul Anthony Luna Jr. I'm 31 years old, and I wanted to take this time to tell you a little bit about myself because no one seems to hear me out on the situation I'm in and why the crime was committed. I'm a heroin addict, and I've been doing heroin since I was 16 years old, on and off because I was doing good working at times, but my demons would take the best of me. So I will fall back into my addiction. The only thing that keeps saving my life is getting locked up, which I hate to say, but it's true. And I thank God for that. I would inject black tar heroin, which I'm not proud of because I've lost a lot behind my addiction. I was strung out dope sick when the crime occurred. If I had the chance, I would ask my victims for forgiveness for putting their lives in danger. I regret doing what I did because I know now I'm wasting my life over a fix. Your Honor, I'm not a bad person. Anybody that knows me can tell you I'm a good person when I'm not on heroin. But every time I get strung out, I make mistakes that I gotta live with, and I'm not proud of it. And the people that don't know me want to paint a picture of me like I'm just an evil person because what they see on paper or go off of what other people say that don't know me. So I'm pleading with you, not for my freedom, but for help with my addiction. This will be the first time I've asked the court for help because I see you're a judge that helps people that want the help. I don't want to keep going back to my addiction because of my weak mindset, and I'm not afraid to admit that. So I'm asking for your help to fix the problem that I have with, which is my drug addiction, because this is a cycle that needs to be broken. So thank you, Your Honor, for hearing me out of the problem in my life. All I gotta say, Your Honor.
all right, thank you. All right, I'm going to sentence you. I am going to ask that you be placed in the therapeutic community.
Thank
They
you.
can address your drug issues. I have no jurisdiction to place you in the therapeutic community, but if you don't ask for it, they're definitely not going to give it to you. You understand?
Yes, ma'am.
All right, the court is going to follow your agreement, sentence you to 20 years in counts 1 and count 2, taking consideration 2024 CR 4237. Counts 1 and counts 2 will run concurrently, give you credit for any time served, There's to be no contact with Xavier Valero, Sergio Martinez, Margarita Segovia, and there's an affirmative finding of deadly weapon. Is there anything else with regards to sentencing? All right.
Nothing for the defense.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we're gonna go off the record for a moment. Here's the thing. You're not gonna be in prison for the rest of your life. It's 20 years.
I understand that.
All right. Once you are released, you need to quickly go to a rehab center to get inpatient treatment. If you end up receiving parole from the prison, they will give you help. They have programs you will need to ask for. If you're released and you can't find a place for your treatment for sobriety to maintain it, if I'm still here, as they say, if God willing and the creek don't rise, you can come back here and I will personally pick up the phone and call someone to make sure you're in inpatient treatment. All right?
Thank you.
All right, good luck to you.
All right, you too, ma'am.
Court is calling 2024 CR 2594, State of Texas versus Mark Anthony Perez. Could I have parties announced for the record for the state
Zach Dunn for the state.
defense?
Raymond Martinez.
And are you Mr. Perez?
Yes, ma'am.
Counsel, have you received all of the discovery and did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Did you review the document entitled Application for Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with injury to the elderly, bodily injury? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Perez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes. Yes, Your Honor.
According to the plea, punishment is to be assessed at 2 years in the prison. State recommends community supervision. They're taking in consideration County Court Cause number 731618. There's an affirmative finding of a family violence, TAP evaluation, follow those recommendations, mental health evaluation, and follow those recommendations, and no contact with Juan Perez. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes. Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor. I understood that.
Did you understand that to be the entirety of your agreement?
Yes. Yes, Your Honor. Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the paragraph entitled Waiver of Appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am. Yes,
Did you
Your Honor.
understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. Did you understand those are recommendations from the state and the court does not have to follow that recommendation?
For sure, I understand.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. State law for states one and attachments. No
Any
objection,
objection?
Your Honor.
Have you spoken with the complainant?
We have spoken with the complainant, Your Honor, yes.
All right, you may continue to confer.
Thank you, Judge.
You're welcome. Mr. Perez, did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor. Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor. Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are we proceeding with sentencing?
Yes, we'd like to, Judge.
Anything you wish to say on behalf of your client?
Judge, what I can tell you is that Mr. Bettis is under a protective order with his father, and he's been abiding by it. Although there was one minor slip up, his brother actually lived next door to his father, so he goes to his brother's house, he was too close to his father's. But he's very, very much aware of what he can and cannot do, and I think he will comply with the conditions of probation.
All right. So, do you have any prior mental health issues?
May I say?
Sure.
Before I was incarcerated, my parents, I understand, my mom, I was getting, I was getting, in the past, I was getting help at the Center for Healthcare Services for my, like, not that, I was on Risperdal, or Risperidone, just for, for anxiety, but I didn't get to do that before, so that's that.
He was having difficult, he's talking about the day of the incident, Judge, he was having a difficult time.
All right. So, other than anxiety, have you ever been diagnosed with anything else?
No.
All right. When's the first time you saw a doctor for mental health issues?
For 2024, I was saying it was in 2021.
So how old were you then?
I was 32,
All right.
36.
Drug use.
I've been clean for the last 2 years, please.
Well, whatever. I understand. I'm trying to figure out history here. So you've been clean for the past 2 years. What have you been clean from?
Alcohol.
And what else? What type of drugs?
I was just smoking marijuana.
All right. So here's the thing. I'm trying to set conditions for you. I don't do cookie cutter conditions because I want people to be successful. But if you're not honest with me about what you use, what's going to end up happening if you'll be sent off in the world unprepared. And then when you come back to court, which you probably will on a motion to revoke, you're going to want to tell me everything about your life at that point. So it's best that you tell me now. So alcohol, marijuana, what else?
That's it.
Okay. All right. Anything else?
No.
All right. I'm going with the alcohol and marijuana. And so nothing else had better come up in your system.
Yes, ma'am.
All right. The court is finding you guilty. Do you have any children?
I have one son. He's 12.
All right. And who does he live with?
He lives with his mother.
When's the last time you saw him?
3 months ago.
All right.
3 months.
3 months ago. All right. As previously stated, court is finding you guilty. The court is going to sentence you to 2 years in the prison, suspended and probated for 3 years. Take in consideration 731618. There's an affirmative finding of family violence.
That's right.
There should be a TAP evaluation How long is the MIC in custody? All right. There should be a TAP evaluation in custody and out of custody. All right. So we'll do a referral to Center for Healthcare Services. If there's some issues with that, Ms. Abrams, then we may have to take it into custody and do the mental health evaluation at that point. So when they give you the referral for Center for Healthcare Services, you had better go.
Yes, ma'am.
Otherwise, what's going to end up happening is you may end up waiting for 30 or 45 days. You understand?
Yeah, Miss Kate, may I say something?
Sure.
That's the first thing I'm gonna do as soon as I'm released.
All right. There's to be regular reporting
Yes, ma'am.
by Zoom or in person.
Sure.
The UA hotline until further notice. There's to be no contact with Juan Perez.
Yes.
There's to be no unsupervised contact with minors. 200 hours of community service restitution. I'm going to order parenting classes. Once he completes those, the community service hours will be deemed satisfied. There's to be 90 sober meetings in 90 days. Field visits. One time per month. For 3 months after he has received documentation from Center for Healthcare Services. So once he gets documentation for Center for Healthcare Services, then 3 months for field visits, then as probation deems necessary. There's to be an anger management course. And MRT. When's the last time you had employment?
So, 2023.
So how you been supporting yourself?
I have jobs that are under the table.
All right, so we're not gonna do under the table in here, all right? So
I have a job waiting for me as soon as I get out here.
There's-
I'm gonna work at the Little Red Barn Steakhouse for the 5th time as a chef there.
all right, so proof of employment within 30 days.
Yes, ma'am.
There's to be no employment as a home health care provider or with minors.
Yes, ma'am.
Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
No, ma'am. Thank you for understanding and bringing me just like that's.
Okay, court reporter is not picking up what you're saying because you're mumbling.
Thank you for everything, Miss. Thank you, Your Honor.
All right, you're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor. Completely understand.
All right, we can go off the record. Here's the thing, to be successful in this court, when you're on probation, communication is key.
Yes,
If
ma'am.
there's an issue, let probation know about it. If you feel as though they're not addressing it, you can always come back to the court.
Thank you very much.
You're welcome. Good luck to you.
Final outcomes. Luna pleads guilty on 2 counts with the repeater true and gets 20 years concurrent plus a deadly weapon finding and no contact orders, while Pettis, on injury to the elderly, gets 2 years suspended, probated 3, with strict treatment, UAs, and parenting classes. 2 cases, same courtroom, massively different consequences based on charge level and history. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, And don't forget to subscribe for more jaw-dropping courtroom breakdowns.
22 CR 4823, State of Texas versus Nicholas Michael Henderson. Can I have parties announced for the record for the state?
Hank Wilkins to the state, Your Honor.
Defense?
Arnulfo Ortiz for Mr. Henderson.
Are you Mr. Henderson?
Yes, ma'am.
All right. Counsel, have you received all the discovery? Did you review it with your client?
We did.
Court will find that the state is in compliance with discovery. Mr. Henderson, I'm showing you what's entitled application for probation. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We waive.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Both counts?
Yes, Your Honor.
All right, we're back on the record. State, are you proceeding on the indictment as presented?
No, Judge, can we, the state waives and abandons counts.
Any objection?
No objection.
All right, Mr. Henderson, I'm showing you what's entitled court admonishments. Did you review that with your attorney? Did you understand it?
Yes,
Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're being charged with theft of a, well, motorcycle, but vehicle, 2,500 to 30,000 as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
I understand.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Henderson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count one only. Punishment is to be assessed at 2 years in the state jail facility. There's a $500 fine. The state is opposing your application for deferred adjudication. They're recommending community supervision. There's to be restitution to Brennan, BRENNEN, Perkins, and this cause number, the theft course, and the MRT course. Did you understand that to be the plea?
I do, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
I did, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Not by me. He had filed one on his own.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with Brennan Perkins. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Ma'am.
Then to the offense is charged in count one. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Your Honor, I submit States Exhibit 1 and the attachments.
No objection.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Are we proceeding with sentencing?
Yes, Your Honor. We request that we follow the prosecution's recommendation.
All right, so you're not asking for deferred adjudication?
We are not.
All right. All right, Mr. Henderson, are you employed?
Yes,
What do you do?
I work in the oil field on a drilling rig.
We would ask that he be allowed to travel outside, although he will reside in Bear County.
All right, do you have any children?
I do
What are their ages?
17 and 16.
And do they live with you or with their mom?
They live with their mother.
Okay.
I get custody of them when they're not in school.
Okay.
However you want to put that.
All right, you've been to prison before?
No, man.
Jail before?
I've been to jail.
All right, for what?
Petty theft and DUI.
All right, and what's up with these tattoos?
Bunch of stuff when I was younger. Just I've grown out of it all.
All right, what's with the arm that's covered in the black ink?
Yeah, that's a whole bunch of cover-ups.
Who did that cover up?
I had a friend of mine do that. It's horrible.
That's not from the ink show. When they do a cover up on the ink show, they do a great cover up.
Yeah, again, like I said, once upon a time type of thing. I've grown out of all that.
And what's the tattoo on this side?
It's just a bunch of like Greek mythology stuff. Again, younger.
Oh, well, who is that supposed to be? I can't tell.
The Mary Magdalene.
She's not a part of Greek mythology, is she? I don't think she is.
No, but the rest of it is just.
Okay.
Like I said, I was a lot younger and a lot dumber.
It's not his fault. He's from Indiana.
Wow.
All right.
We got watermelons too.
Okay. Well, hopefully they're sweeter than what's at the HEB. You know, I'll be the stereotypical Black person. I love watermelon, especially if it's sweet. This season hasn't been that good, though, Robert Porter. It's been hit or miss. All right. This is what the court is going to do. The court will find you guilty. The court will sentence you to 2 years in the state jail facility, suspended and probated for 4 years, 200 hours of community service restitution, probation. Since he's going to be working in the oil fields, if he wants to pay that off at $7.25 per hour to the San Antonio Food Bank or some other charity that the court would approve of, you can do that as opposed to the community service hours.
Okay.
The theft course, the MRT course. There's to be regular reporting by Zoom or in person, regular UAs, or you can do the patch. And usually a patch doesn't work in all fields, but probation can go over that with you. There's to be no contact and restitution, if any, to Brennan Perkins. And we'll do field visits 1 time per month, probation, and you can just check to see how things are at the home and make that one visit a random visit. And if you think he needs more, then you all can do it as needed. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. And probation, if he's working in the oil fields, then he's allowed to work in the oil fields. Probation is, does he need anything else? Do you need anything else from the court to be successful?
No.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. The MRT course is supposed to teach you how to do what's right.
That's moral recognition therapy.
Yes,
Yeah,
but you
I've heard of it.
should know the difference between right and wrong. How old are you?
I'm 39.
It's time to stop the foolishness. Otherwise, you're going to find yourself in somebody's prison be it Indiana or Texas or wherever. People don't like their property stolen. All right, good luck to you.
Thank you, Your Honor.
Thank you. Court is calling 2022 CR 8453, State of Texas versus Mark Daniel Lewis. Can I have parties announced for the record for the state?
Hank Wilkins with the state, Your Honor.
Defense.
Ed Piker for Mr. Lewis.
And are you Mark Daniel Lewis?
Yes, Your Honor.
I'm showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Mark Daniel Lewis who is placed on community supervision in 2022 CR 8453 for the offense on unlawfully carrying a weapon with a felony conviction on January 13, 2023 for a term of 10 years? Is that you?
Yes, Your Honor.
State?
Honor, violated condition number 15G, on or about the 26th day of May. And Judge, I'd like to orally.
Oh, just one moment. Excuse me. Could you, if you all could move to the other end. Okay. All right. Are we proceeding on the motion as presented, State?
Judge, we'd like to orally amend. I've conferred with defense counsel. We'd like to orally amend the year. It should be May 2023 instead of May 2026, Judge.
All right. Any objection?
Judge, I confer with my client on that and we have no objection.
All right, Mr. Lewis, do you understand that that's a substantive change to the motion to revoke?
Yes, Your Honor.
Do you understand that your attorney has 10 days to prepare for trial?
Yes, Your Honor.
All right. Did you wish to proceed?
Yes, Your Honor.
All right, State.
On or about the 26th day of May 2023 in Rusk County, Texas, the defendant, Mark Daniel Lewis, did then and there fail to comply with the rules, regulations, or instructions.
Excuse me, just one moment. Were you changing that date?
Yes, Judge, to 26th day of May 2023.
Okay. All right. Thank you. Sorry about that.
Sorry. In Rusk County, Texas, the defendant, Mark Daniel Lewis, did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Treatment Facility, in that the defendant was behaviorally discharged from the East Texas State ISF unit in Henderson, Texas, in violation of condition number 15G.
How do you plead to that? True or not true?
True.
All right. Did you understand by pleading true to violation 15G, the court could find it true, grant the motion, sentence you to 6 years in prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of 15G?
Yes, Your Honor.
Court will find violation of 15G true. Is there an agreement?
Judge, we don't necessarily have an agreement. I have no objection. The defense counsel has spoken with probation and we've conferred, and I think he has a proposal that he'd like to make to the court that the state has no objection to.
All right, Mr. Piker.
That's correct, Judge. And then I will call my client because he knows better what happened than I could ever tell you.
All right, Mr. Piker, what are you requesting?
I am requesting that the court consider keeping him on probation, not revoke him, and move him out of, don't revoke him, don't send him back to that facility and send him to lifetime recovery. We've looked into it. It's a 3-month residential. He's motivated. Actually, it was his suggestion that if that was possible to get him out of there, he wants to help. He wants to get off the drugs, but he can't do it where he's at.
Okay.
And he is going to explain that to you better than I can.
All right, Ms. Abrams.
I apologize. I cannot hear.
On this case, it is Mark Daniel Lewis. There was an incident at Henderson, and his attorney is suggesting that he be placed in inpatient at lifetime recovery.
Your Honor, probation would not have any objection.
Okay. And so that I will know, what is the issue with that facility? We'll say allegedly.
Would you like to hear it from me or from Mr. Lewis?
Either one.
Mr. Lewis can explain it better than I, but I will tell you that he was in a gang. He was in a gang when he got there. He wanted out of the gang. He told him he wanted out of the gang. His life was threatened. His well-being was threatened. And quite honestly, from what he tells me, there was so much drug usage there and fight night that it was not conducive to getting better. It made it worse.
All right. And this is at the facility in Henderson, Texas?
Yes, ma'am. He will swear, he will tell you that under oath.
Oh, no, I'm going to make sure that the facility at Henderson, Texas, that we do, that a spot check is done, random, so I can figure out what's going there, because the last thing I want is someone who's trying to get treatment and wants treatment to be sent to a facility where it's difficult to receive that.
And that's why I wanted to address you, because I knew you'd be interested.
All right. You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name.
Mark Lewis.
All right, so tell me what is going on at the Henderson facility.
Whenever I was here in this courtroom on January 13th, I signed for the 10 years probation. You gave me the choice to go receive help or go to TDC, where, so I chose the help. And whenever I was finally transported to Henderson, Texas, I threw myself into the program and I started learning about thinking errors. I started learning all the aspects I needed to learn for my first track, which was cognitive intervention. And I had a very successful 45-day call. But during that time, I made the decision to step away from the gang affiliation that I was affiliated with. And I made it known that they were doing fight nights. There were people over there still smoking K2.
Fight nights?
Yeah, it was disrupted. The counselors would come in and they would read from a piece of paper for an hour and they would leave until the next day. And it was back to the same stuff. And I made it known that I didn't want no part of any of that anymore. I was trying to get back to my daughter. I let everybody know, like, I was back in my Bible. I was trying to get myself right. And a lot of people took that offensive, and they threatened me, and they were trying to jump me. And thankfully the guard was able to see that something was going on, and they pulled me out of the dorm that I was in, and they placed me in a single man cell in restrictive housing. And when they came, they were like, they wanted to send me back to that environment. And I wasn't trying to go back to that environment because of the threat. And they said that by refusing that environment, I was refusing the program. And I knew that I would have to come back here and address you, but I'm trying to do better.
Okay. No, I appreciate that. So what I'll do then is I'll deny the motion and I'm going to alter and amend conditions to include lifetime recovery, the inpatient, and you'll be transferred from the jail to lifetime recovery.
Yes, Sean.
All right. Is there anything else?
That was it.
All right, we can go off the record. See what I mean about communication being key? If I don't know this is going on, then, but thank you so much for letting me know.
Thank you, Your Honor.
You didn't get any more tattoos while you were there, did you?
No, thankfully not.
Okay.
Thankfully not.
And he's not from Indiana.
Okay.
Okay.
All right.
Thank you, Your Honor.
Final outcomes. Henderson is found guilty, but gets 2 years suspended and 4 years probation loaded with restitution, theft/MRT courses, reporting, and strict compliance, or that state jail time snaps back fast. In Lewis's revocation, the judge finds the violation true, but denies revocation, instead amending conditions to send him to lifetime recovery inpatient, emphasizing that communication can literally change the outcome. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.